I know that background, Greg. I've used it.
Okay, Howard, do you want to get started?
Sure,
Should I give you a little intro, or do you want to intro yourself?
whichever you prefer. Can I have the sharing? Uh,
Yeah,
Make me a co-host or something.
make co-host. Okay, there you go.
Horrific.
Okay. So, guys, super excited to have with us Howard. He has over 3 decades of experience to help solve your problems. He's super interested in the comedy world. He's worked with the National Comedy Center and has been involved in a lot of litigation to help comedians. He's also performed as a comedian, so we're going to get him back on stage soon.
We all make mistakes.
So if you can add what you want to that, but I'm super excited. I work with him myself personally, and he's been great. So if you have any questions, we'll have them after his presentation, and if you don't want to ask them, you could just put them on the side in the comments, and I'll read them.
Yeah, I put them in the chat. I know my students hate asking questions live. So anyway, hello, welcome. Give me a second to just adjust things here. There we go. All right, so I am Howard Lieb. That's me. As Felicia said, I am an attorney. I This is the 40th year that I have been practicing, which just means I'm old, but that's life. Um, I am an entertainment and intellectual property attorney. I do copyright and trademark and general entertainment work. I come out of a background from the music industry. I used to be at what was called Marshall Morris, Wattenberg and Platt. I call them the big time, big deal music firm, where we worked with and I represented Kiss and Whitney Houston and BB and CC Winans. I've been practicing on my own for the better part of 30 years. I have that cold that's going around that has you coughing for weeks at a time. I have my tea right here, so I apologize. Um, I practice out of Ithaca, New York. I spent most of my life in the city, but I moved up here about 15 years ago, and this is where you will find me. Uh, More about me as we go along because that's how I teach. I also teach, in addition to practicing, I teach entertainment law and music law at Cornell Law School, Syracuse Law School, and Truro Law School, and also trademark law at Syracuse. Also, I teach for a couple of programs in China and one in the Ukraine and Poland. So, I stay busy. Let's see, what do we got on the slides? Let's hop over here. There we go. So what we're going to do tonight is what I call Stump the Lawyer. I've done this for lots of different groups. Uh, Basically, I'm going to do a little bit based on the questions that were already sent to me. And then feel free to ask me whatever you want. It's free legal advice, except it's not legal advice. The caveat up front is you're not giving me enough information to give you good, solid, this is what you absolutely should do legal advice. I'm giving you general pointers, not things about your specific situation. And with that legal caveat out of the way, on we go. Uh, so the first question I got was, when do you need an entertainment lawyer? At what point in your career? Uh, the real answer to that is ideally when you start. From the moment you start, you're making decisions that will affect what happens to you all the way through your career. How you protect your material, what material you do. A lot of comics, and as Felicia said, I spent a year on the stand-up audition trail, oh, so many decades ago. Uh, but I worked primarily out of the comic strip. A guy named Scott Blakeman was the head MC there. And I took his course at the New School back in the day. If I'd waited 6 months, I would have taken it with Jon Stewart. And who knows, my whole career might be different. But the fact is, early on, a lot of comedians, shall we say, borrow material from other places. This is not a good thing. There are all kinds of legal and community sanctions about it, but it happens. but understanding the rules about what you own, and we'll talk about this some going forward, when you write a joke, how different your jokes have to be, how different your routines have to be than other people's for you to own them, and also how different other people's material has to be from yours. And we'll talk about the difference between the legalities of copyright and the comedy community sanctions concerning infringement and all, because they are different. Believe it or not, there's an awful lot of law review articles about this out there, and I've read most of them because one, this is an area I care about, and two, another thing I didn't mention, I have been serving as an expert witness in a litigation that a group of 11 comedians and comedians' estates have brought against Pandora, claiming that Pandora is not paying them for their underlying comedic literary material, meaning the material that they wrote as opposed to the recording of that material. We'll talk more about that later on as well. So when do you want a lawyer? Well, you want to try and identify a lawyer anyway early on. For most people starting out, if you're starting out either young or this is your primary field, then you're probably not going to have a ton of money to hire a lawyer, but it never hurts to reach out and talk to a lawyer. At least get to know somebody so that if there is a problem, you have somebody you can call. You're already armed and you're ready to go, as opposed to trying to find that as you go. How do you find a lawyer? Well, there's me, so there's that. But in terms of just generally finding a lawyer, talking to other people who have used lawyers. Did they have a good experience? Do you need an entertainment lawyer? Well, that brings us to what is an entertainment lawyer, or what is entertainment law? And while there are a lot of highfalutin academic definitions of what entertainment law is, the definition I use and I give to my classes is generalized law for a specialized clientele. Why? Because in addition to all the things you would think about as being part of entertainment law, like performing contracts and copyright issues, trademark issues, and such, entertainers also have the same issues as non-entertainers. Buying a house, doing an adoption, having an issue with their landlord, small claims court issues. And so, as an entertainment lawyer, I have dealt with a lot of weird issues for people who are entertainers. Paul Stanley of Kiss once came into my office wanting to know why there was no rock star exception to jury duty. And I had to explain to him that the law doesn't recognize rock stars as a category that has special exceptions. He wasn't happy with that answer. But we just changed the rules. So even the governor had to do jury duty and had to explain to Paul he was probably not getting out of it. A lot of entertainers, especially starting out, will use a friend, a relative, a friend of a relative of a friend. Uh, One thing to look out for: it is all good and well to have your college roommate's father, who is a real estate attorney, look at your real estate contract. But if you're doing a deal with Netflix for a special, you probably don't want that person doing it. The entertainment side of the industry is a specialty. There are norms and definitions and such that people who practice in other areas don't know. That's not their fault. I'm not the best person to come to for a real estate issue, and I certainly wouldn't come to me if you were charged with a crime, because you're likely to end up in jail. It's not an area I've ever practiced in. Uh, but when you do practice in an area for decades, you learn the norms. You learn what's expected. You learn how to speak to people on the other side. So the short answer to the question, at what point in your career do you need an entertainment lawyer? You need one when you start having legal work to do. Now, a lot of people, will negotiate their own contracts and, mark them up, and even, heaven forfend, draft their own contracts. Uh, People do that. They pull things off the internet to use. The problem with that is, as with everything else on the internet, You don't know if the stuff you pulled down is any good or not. You also don't know which side it was written for. Contracts are written to protect one side or the other. They're not usually, even-handed documents. And if you pull down a document that protects the record company, who is signing, and you're doing a deal with the record company, you're going to get screwed. So you don't really want to do that. I will say I'm of the belief that all contracts should be in writing. The handshake deals aren't worth the paper they're written on. To quote the guy from MGM, I forget his name. You should consult with an attorney. I do also understand that attorneys are expensive. I've often said that if I weren't me, I couldn't afford me either. But the reality is, you're looking out for your future. Lawyers don't make you money, but they can protect you from losing money. And they can protect you from going into a deal where you suddenly find that you've signed to a label for 7 years and they're giving you no money up front for it. That's not a good deal. One of the things an entertainment lawyer can advise you on is, are you getting a good deal? Are you getting a decent deal? Are you getting a normal deal? Uh, because as entertainment lawyers, we know these things. We've done them. Ask me things about this topic before I move on to the next one, because I only got an hour with you guys, and I don't want to run out of time. Oh, you're just like my law students. You don't ask
Mm.
questions. Oh, there's something in the chat. Let's see
They
what
said
we
how
got here.
that's really helpful, they said.
Well, good. That's what we're here for, is to be helpful. Let's see. Normally, I tell my students that before the end of the production, uh, I will have told jokes, done voices, and sung. I don't think I'm going to sing tonight because you can hear what my voice sounds like. All right, we continue. So the next question, and this relates to the other questions that I received. I'm typically concerned when my jokes are being up. Something else that popped up in the chat. I don't want to get ahead of myself here.
No, it's just an LOL.
Okay, good. I love when students laugh at my jokes. Absolutely. It's the primary reason I teach these days. I don't do stand-up anymore, but I grade these people and they have to come to class. So, they're locked in and they may as well laugh. I tell them that beginning of the term. So I'm typically concerned with my jokes being stolen after a show or an open mic. If I don't post it on Instagram to prove it's mine, is there any way to protect my material other than that? Well, yes, there's lots of ways. Now, the problem, first off, posting it on Instagram doesn't prove it's yours. It just proves you posted it on Instagram. I can go to a club, listen to you guys and go and post your entire routine on Instagram. Doesn't mean I wrote it. The reality here is there's two things going on. And in order to understand what's going on, you need to understand a little bit about copyrights and what they are. How fortunate that I have stuff on the slides that will help us with that. So, what is a copyright? A copyright is an ownership interest in the expression of an idea fixed in a tangible medium. Legally, that's what it is. The ownership interest is if you own the copyright in the material, you get to do with it what you want. You get to tell other people to back off. You get to tell other people that they can make copies of it, that they can make what are called derivative works, which are secondary works based on the original material. You control that. That's the ownership interest. As to the issue of derivative works, and this will become important in a little while, understand that when you're writing stand-up material, whether you're writing it on paper or you're writing it, quote unquote, live in front of an audience, as you improvise or you alter material, that is the original creation. When you record it later on or when you revise it, those are all derivative works based on the original work. The original work is the first thing you want to think about protecting, because everything else stems from that. It is very important to understand, and a lot of people don't, that in a copyright, you only own your interest in the expression of an idea. You cannot own a naked idea. So, trying to think of So, Henny Youngman's classic, Take My Wife, Please. It's perhaps the most classic Borscht Belt style joke there is. He can own that. But when Andy Kaufman was up on stage, doing his impressions as the foreign man, I think is what he called it, and going, "Take my wife, please take her." That's different. Now there are reasons why it's different, not just the wording, but how it's being used and all the rest of that. Henny Youngman could not have stopped Andy Kaufman from doing that. It's too different, both in content and in how it's being used for it to be a copyright infringement. Let's see where I have it. There we are. So copyright does not protect ideas. If you have a joke about, oh, I don't know, you know, well, I come from an earlier age, so let's say a joke about your mother-in-law's, cooking. I'm sure none of you are doing jokes about your mother-in-law's cooking. But I'm old, as I said. I never did any of those either. But okay, so be it. That doesn't mean that you now own the rights to all jokes about somebody's mother-in-law's cooking, let alone all jokes about mother-in-laws or all jokes about cooking. What you own is your expression of the idea. To take it to a different area, you can see on the slide, hopefully some of you at least know the TV shows Lost, The Walking Dead, and Yellow Jackets. All three of those are shows about a group of people, disparate people, who through some semi-supernatural machinations have found themselves in an adverse situation from which they have to try to survive. I would describe all three shows. I would also describe Gilligan's Island and the Brady Bunch, maybe not the supernatural part. Sherwood Schwartz is the guy who created both the Brady Bunch and Gilligan's Island. And he said they were the same show. They were a group of disparate people thrown together by circumstances, trying to figure out how to survive together without killing each other. And if you look at it, that's how it works. And by the way, just having nothing to do with this, you can turn any situation into a sitcom by simply adding the phrase, "and humorous complications ensue." If the bombs fell, people blew up, buildings fell, and humorous complications ensued. And you've got a sitcom. You cannot own the underlying idea here. Each of these, Lost, The Walking Dead, Yellow Jackets, Gilligan's Island, The Brady Bunch, were different expressions of that idea. And that is why the use of copyright, the legal, file it in Washington, copyright, can be difficult for comedians. Because when you have a joke, it is very easy, sometimes it's easy, for somebody else to take what you've written, turn around the meter, turn around a few words, and alter it somewhat and come up with a very similar, but still different expression of the same idea. So that is why traditionally comedians did not file registrations for their underlying comedic literary material. Now, that is not a good idea, and I'll explain why in a moment. But going back, and I've done a lot of research in this area, going back to the vaudeville days, people didn't file copyright registrations. In fact, what existed in the vaudeville days, where there were several different registries that agents and or newspapers held of vaudeville comics routines. And you would take your routine, you'd write it down, you date it, you put it in an envelope, you give it to this agent or the newspaper, and they'd put it in their vault or a drawer. And if there was a dispute over who owned a joke, the two comedians would go in, they'd pull their envelopes out, they'd look to see, first off, did both of them have the joke? If only one did, the person who had that joke won. If they both did, whoever had the earlier date won. And the beauty of winning in that situation was, if you didn't take the joke out of your act, then people would stop booking you. It was a wonderful enforcement mechanism. We don't really have that anymore. As a result, you are really left with two things. You are left with the community and you are left with the law. The community, the community tends to enforce what would otherwise be copyrights, pretty strenuously. You guys know, and I'm sure you've been told, that the idea of stealing jokes is a major league no-no. If you've seen the amazing Mrs. Maisel, her in the first episode, her husband's on stage, doing a Bob Newhart routine. I produced the Bob Newhart CD many moon ago. Never got to meet him, but I did produce. It was a collection of greatest hits for Shout Factory, and I forget. I think it was the Abe Lincoln routine, and he's up there doing the routine verbatim. It was an earlier time. People weren't as tuned in. There wasn't much comedy on TV. Some, but not much. Today, that would get you, if not booed off by the audience, who might or might not recognize the routine, certainly would get you a cold shoulder from other comedians. Comedians tend to be possessive of their material. It's not easy to write comedic material, as you guys, I'm sure, have learned. I certainly learned it. And even harder to write good comedic material. And you don't want somebody ripping you off. Now, the problem is sometimes two people can create something that's essentially the same. I had that happen to me. Back when I was doing stand-up, there was a commercial for something called the Civil War chess set. The Civil War. Men die. Women wept. You have all the fun of the Civil War in your own home with a great new Civil War chess set. It goes on. Saw the ad. It was a real ad. I riffed on it. It was one of my better bits. And then one day I'm watching a Robert Klein HBO special, and he starts doing the Civil War chess set. It's not exactly my routine. It's close enough. I don't think he stole it from me. I mean, I don't think he ever saw me do it. I would be honored if he stole it from me. But he saw it, the same ad I did. And I have been told by people who know us both, and I've met him a few times, that we have similar senses of humor. He is my favorite stand-up comic. And so it hit him the way it hit me. How do you know if somebody's stolen from you? You don't always know. The first thing to ask is, was there an opportunity? Were they in the audience? Did they see you? There were many reports of Robin Williams and Carlos Mendez and many others stealing material. True or not? I don't know. I'm not inside their head. Williams kind of owned up to it, claiming he didn't do it intentionally. Mendez never owned up to it. But again, this is the sort of thing you can talk to a lawyer about. In terms of copywriting your material, other than Instagram, putting it up on Instagram serves some purposes. It stakes a claim. On this date, I put that up. I said it was mine. That doesn't stop the other person from saying, yeah, but you stole it from me. But it is at least some form of what would be evidence that as of that date, you were staking a claim. The downside, of course, and this is a problem with the industry today, is that by putting it up on Instagram or TikTok or wherever, you're burning material. Material has a shelf life now of 5 minutes. In the days of vaudeville, a good solid 20 minutes could last you 2 years as you went from venue to venue to venue. Now a good solid 20 minutes lasts you 20 minutes. And the more you posting is a good thing. It's got publicity reasons for doing it, developing an audience, etc. But it also puts your material out there so that one, everybody knows it, and two, people can steal it. So let's talk a little bit about, whoops, there we go. Why file a copyright registration? First off, let me say you don't necessarily need a lawyer to file a copyright application for a registration. It is a fill in the blanks form. It's all done online. It's relatively simple. I urge my clients to try and do it themselves. I was one of my mentors was of the belief that clients should do some things for themselves, and this was one of the things he thought they could do. If you want to sue to enforce your rights as to your material, you must file before you're allowed to bring suit. It's just a statutory prerequisite. You cannot file suit until you have registered your copyright, which means it's gone through the process and been approved. Now, for an extra payment, I think it's about an extra $100, you can get it through the system in about a week. So it doesn't need to delay you very much. But if you file your copyright registrations before you are infringed, the law allows you to get what are called statutory damages. That means that a judge can simply set what the damages are, anywhere from $750 to $150,000 per infringement. Why is that an advantage? Well, how are you going to prove the monetary value of somebody taking your best line, especially if it's somebody higher up on the food chain, so who has access to being on TV or having a Netflix special or whatever it may be, so that people now believe the line is theirs and aren't going to believe you had it first. It's a loss. It's a real business loss. But what's the value? Very hard to prove. Statutory damages allow you to bring suit and basically leave it to the court to figure it out. It may be that they go on the low end, but if you can show that the theft, was intentional, then they can be on the high end too. It's going to be much simpler than trying to show the actual value. The other advantage of filing a copyright registration beforehand is the information in your registration is presumptively true in court. So one of the things you have to tell the Copyright Office is what it is that you're protecting. You have to send a copy. You could send an audio recording or a written transcript or a video recording of your routine. And you don't have to do it joke by joke. You can copyright a routine or a whole set. And you have to tell them when it was created. And then if you have that copyright certificate, you get to walk into court and go, ta-da, I have this. And while the other side can bring in evidence to prove that that's false, that you lied to the Copyright Office, they have the burden of proving that because you have your copyright certificate. Without having that first, you have to prove that you created it, that it was created as of that date, et cetera, et cetera. So it is a much easier lawsuit to bring if you have your copyright certificate. Now, copyright filing can be expensive. I think right now it's about $50 per registration out of pocket. What some people do, they will take an entire, show's worth of material and file that as a single copyright. There are some issues with doing that in terms of how much you can get. Pandora, the next slide. Yes. I mentioned the Pandora litigation. The estates of Robin Williams and George Carlin, Louis Black, and others are the plaintiffs in that matter. As I said, I'm not the lawyer in the matter. I'm an expert witness in the field of comedy and copyrights. I cannot tell you how happy it makes me that I'm doing that. And one of the issues that we're going to have to resolve, that the court is going to have to resolve, is whether we are allowed to get damages on each routine that was infringed, assuming we win and they decide it was infringed, or only per record, per CD worth. Based on my reading of the cases, and I've read a lot of the cases about this, I think the better law is, regardless of how the copyright was filed, since comedy is generally done on used on a per routine basis, and certainly since that's how Pandora puts it out there, statutory damages should run, I believe, on a routine by routine rather than a full set by full set basis. That hasn't been resolved yet. Is case law about it, but in our case, it hasn't been resolved. And by the way, to understand the Pandora suit, you need to understand that in any recording, there are two copyrights. We'll talk about it in terms of music because it's sometimes easier to see there, and there's a lot more case law on it. When you record a song, you would own the copyright in that recording, and whoever wrote that song, whether it was you or somebody else, owns the copyright in the song itself. So the song New York, New York, written by Fred Kander and Joe Ebb, they get paid every time it gets recorded or played, but Liza Minnelli's version only pays Liza Minnelli, and Sinatra's version only pays Sinatra. Both of them pay Kander and Ebb. In comedy, there has never been a methodology for paying comedians for the material that they wrote, which has been recorded. There are now two organizations out there, Word Collections, is my client, you think I know, and Sound Giants, I think, that are serving as organizations that will collect these monies from Pandora, Spotify, SiriusXM, Apple Music, etc. This is all very new. They are still in their startup phases, but they've signed up these 11 comedians and some others as well, and they are suing Pandora. When Pandora definitely pays royalties for the recordings, that's not in dispute, but they are not paying royalties for the underlying material to comedians, even though they do for the underlying material for musicians. And in fact, if you have a musical comedian, Steve Martin's King Tut gets paid for both, but Steve Martin's Excuse Me does not. A moment. So in the Pandora litigation, one of the issues that came up a few times is whether or not material was copyrighted before the infringement took place. Because if it wasn't copyrighted before the infringement took place, then those routines are not eligible for statutory damages. And in a situation, a litigation like that, statutory damages really are the name of the game. All right, I think that's everything before the other questions, which also deal with copyright. Ask me things relating to what I've said before I go on.
I have a question.
Sure.
If you
You're in the
don't,
room, you're allowed.
yeah, if you don't copyright it, and just say theoretically someone copyrights a song, but I have evidence of it being the same exact thing being recorded before they copyrighted it. Doesn't that make me innocent?
Well, not necessarily. It depends on what's happened. Again, I can't give you everything, but I can answer your question. What you're saying is essentially they lied on their copyright certificate,
Well,
correct?
they didn't hear me say the joke.
Okay. Oh, you said song, so all right.
Yeah, joke,
Well,
sorry.
all right. That's okay. Independent creation is a defense to copyright. If you write a joke and I, without ever hearing of or knowing about your joke, write the same joke, I am not infringing your copyright because by definition, I didn't infringe. Now, it would be really easy for anybody to say, well, I created it myself. It was independent. It doesn't matter. So the law, I wasn't going to get into this, but I will, to
Mm.
show copyright infringement, what you have to show is the similarity between the two elements and that there was an opportunity for copying. So you have to show where the other side could have gotten access. Not that they did, but that they could have. So if you wrote this joke and you stuck it in a drawer and never told it to anybody, and somebody else then comes up with it, that's not copyright infringement. And you're not going to be able to show that they copied it from you, even though the jokes may be word for word identical. It's that classic, if we had 1,000 monkeys and 1,000 typewriters for 1,000 years, the one that types Moby Dick would be able to get a copyright on if we let monkeys get copyrights, which we don't. And yes, there's actually case law on that. The other side gets to come in and say, I not just say I never heard of it, but again, if you have your copyright certificate, which is prima facie evidence that you own this, they have to show that it was, to a jury's satisfaction, that it was unlikely that they ever had access to it. Those issues do come up, not often in the area of jokes. There's not a whole lot of litigation on jokes. I have read, I think, every case that has ever been written in the area of comedy, because I've been doing it for a long time. I started when I was in law school. And while they are usually contract disputes. Victor Borga got sued over the phonetic punctuation routine because two other people had written it with him, and he just stopped paying them. But over joke stealing, for the reasons I talked about, the comedy community tends to take care of that in-house. We hire somebody with a big club to come after you, and I don't mean like a comedy club, as opposed to going through copyright litigation, because the value of the copyrights, the stolen copyright in a joke, is so much less than the cost of a litigation that nobody's going to spend a couple $100,000 on a litigation to make $7.43 from that, the stolen joke. That's one of the reasons that comedians have never gotten paid for their underlying material. It never made sense to bring the suit. Now, with an organization that is representing multiple comedians and sees opportunities out there to represent more and have an ongoing business, actually two organizations, the financial issues have changed some, and it makes sense. I answer the question, Felicia?
Yeah. The other question I have is it true? Someone mentioned to me that if you post something on Instagram that they essentially own it then?
No. What the issue is, the terms of service. They don't own it. None of these terms of service say they own it. What it does say is they can do things with it. They can license it. They can't sell it out from under you, but they can permit other people to make use of it. They can, and many of these organizations allow AIs to scrape your material and feed them. You would have to look at the specific terms of service to see what they can do. And of course, you and I and everybody else on this call and in the world have not read the terms of service, so we don't know. Uh, to a point that we've talked about before, I was told by SiriusXM's lawyers that they do not require the record company to take the copyright. Still, I can see why it might be a good idea to do that, because the record company's in a position to protect things. It's all about what the contract says. And other groups might. He only represents Sirius. But it's all about what the contract says, or the terms of service, which are part of your contract. And generally, these organizations, Facebook, Instagram, TikTok, they do not take ownership. They wouldn't have been able to flourish if they did. But they are allowed to, license your posts, to let other people, download your posts. They probably could not license somebody to go out and perform your material. However, I haven't read the terms of service, as I said, but I think that would be above and beyond what they allow.
Hmm. Yeah, it's very difficult. It's a very, obviously comedians are very upset about a lot of it, and like for reasons that you're saying, it's hard to like I don't know how people feel about actually stealing the joke, but like I know like you'll do a joke and suppose I have a joke about like Netflix and says, my son, I always know my son's gonna call because he always calls me after I change the Netflix password. And then like a week later, I see another comic doing a joke, and this is ages ago. Like my mom called me for the Netflix password. She says, "What is it? My birthday." So obviously, inspired the joke, but he was able to just redo it the way he wanted to do it.
And this is not new. This I
Yeah.
have I've done a bunch of radio comedy shows over the decades on various radio stations. And it's always been thematic. I'll take a theme and I'll play comedy routines. I own about 6,000 comedy records. And one of the shows I would do from time to time is what I call comparative comedy, where I have basically the same routine being done by different comedians. I have one by a Miami, lounge comic doing the same line, and possibly before, I'm not sure, George Carlin does the line. I've got another, lounge comic doing the same routine that Flip Wilson does. Uh, People steal material. People stole material in vaudeville, in burlesque, in the comedy club era. And one of the reasons is it's easy to do.
Do you
It,
consider
it
that stealing material, though?
what was that?
Do you consider that stealing material? That situation?
I don't know. I mean, there is no hard and fast definition. I don't know that that would pass muster in a copyright suit. There's enough change there that it probably is a separate copyright thing. But in terms of community enforcement, it's the same concept, and the laugh comes from the same place. Uh, and we have, now I'm putting on my court jester hat. Yes, I have a court jester hat. And I would say that is theft of idea, which may in fact be different than copyright infringement. There's a difference between copyright infringement and plagiarism. That might be plagiarism, but not legally enforced. It's not a satisfying answer, that I know.
Does anyone else have any questions? You can
I
put
mean, I
your
have
If
two more
that,
that
yeah,
you
I have a
that,
question really quick. If that is infringement or if that is plagiarism, is there a way to protect against that as well? Or is there another, I know we're talking about copyright, but is there like another way to protect against plagiarism? Essentially, is my
well,
question.
some comedians threw Robin Williams up against the wall at the Holy City Zoo and threatened his life.
Oh.
So there's that. I mean, that's one way of doing it. There's slipping the bouncer $20 to break somebody's arm. There's bad mouthing people. I mean, the problem is that we don't have a lot of enforcement. There's not a lot of enforcement mechanisms. I mean, you could try going to small claims court, but even that's a pain in the ass. Who wants to spend a night, in Manhattan small claims court? I've been there. It's not fun. But you know, the community tends to be self-policing. And if in fact somebody has done that to you, and you're absolutely sure that that's what's happened, because I would not do this lightly, because if you do it lightly, you'll get a rep. Make noise. Talk to the head MC. Talk to your friends who are comedians. In Chicago, I just finished recently a book about the Chicago stand-up scene. And somebody there was a noted plagiarist, for lack of a better word. And when he would come on, comedians would either turn around their backs to him, and when he was in the room, some comedians refused to go on, stating why they wouldn't go on, or switch to older material. Again, stating why they were switching to older material, because he was just a notorious joke thief. And
Who was
the
this?
community tends to be self-policing and supportive. Sorry, Brian, did I cut you off?
Who was that? No, I just wanted. Who was that? The
I
notorious.
don't remember who it was.
Okay.
The book is called Just the Right Amount of Wrong. I think that's the name of it. It's just the right amount of something.
So Brian, you had a comment?
No, I just yeah, it's a difficult issue to navigate. I just highly recommend shame within the community. We really because it's really there's so much difficulty in the but really don't do it. I just encourage whenever I teach classes and everything else, don't steal material. I always try to find out. I even Google jokes. I even go on Twitter to go, did somebody say this? Somebody probably said this. There was a joke that I thought, oh, this is really funny. And then I go, wait a minute, it was about like the Cleveland Indians are changing their name to make it less degrading. And so they're just going to call themselves the Indians. Okay. Because the joke, and I thought that's really clever. And I was going to post it. And then I go, wait a second. Like I go, that's very clever, but I think that sounds like something that another comedian probably might have thought
Yeah,
of. I didn't hear anyone do it, but it has that kind of formula to it that I go, I'll bet you somebody, and I Googled it, and sure enough, somebody did. And
yeah.
I just said, okay, that was off the list. And you think, oh, I'm really clever, and then you go, oh boy, and that joke was really funny. I didn't see anyone do it. I thought but there are formulas to comedy. There are things like that, and when you think of something and you go, oh, I think nobody said this, you'd be surprised. There's a lot of brilliant comedy minds out there, and some not even that great, but the thought process is very similar. So don't do it, guys. And when you do think of something, go put it through your filter and go or Google it or try to find out. And because it's the worst thing you can be. It's really the child molester of the comedy world is the joke thief, right?
Yeah, but it's so on the other hand, on the flip side, it's so hard because, like you said, you came up with that idea independent of someone else.
Yeah.
And like I know, like just doing my special, there were a lot of jokes that I've been doing for lots of years, and then I know like Amy Schumer's special came out like 6 months before me,
Yeah.
and she was dealing with Ambien, and I know I did my jokes before her jokes, so it's like
Yeah.
it's
I
hard.
stopped
That
doing the
can,
Civil War chess set routine after I heard Klein do it, and
Right,
I know I did not hear him do it before that.
right.
and there's sometimes when you hear, all right, somebody's doing something, or there's something that's similar. I have a Bigfoot thing. There's some guy and somebody, or there's a guy that does a Bigfoot routine. But it's like, of course, somebody does a Bigfoot routine. And the fact that there's a show called Finding Bigfoot and they haven't found him, I didn't think that I was on the cutting edge of comedy right there when I did the piece. But I did think the bit that I wrote is very original in terms of I'm going to go a different direction with it. I'm going to cover jokes that no one had written. And of course, somebody might go, oh, you got that. No, I didn't. It's an obvious joke. It's like the big Finding Bigfoot routine that nobody has and nobody's found Bigfoot. So what you want to do is take the premise and try to do as original a take on it as you can. If you find out that somebody's done it, but also it's you're going to write jokes and then you're going to find out somebody, oh, damn, like Felicia's saying, oh, somebody has done that or somebody's done that. What do you do then? Well, you take pride in the fact that you thought of it as well. You don't necessarily have to stop doing it. But like Howard was saying, if it's a high profile situation where somebody like Robert Klein does it on an HBO special, it puts you in a difficult position, and then you have to make a judgment call. As long as you know that you're not a thief and your conscience is clear. But there's also times when you have something, maybe you saw somebody do something and maybe I did see a comic do something, and then you go, oh, did I get that from somewhere? I sometimes think that. Did I hear somebody do that? That's there's nothing you can do about that. You can only go, okay, if I did, then I'm not going to do it. And I find out who it was, and then I'm going to exit out of my act and then just keep writing. That's the only thing you can do.
Yeah, unconscious. Look, as I said, I have 6,000 comedy records. When I was trying to write stand up, I was deathly afraid that I would pull a joke from one of them without realizing I was doing it, because I agree with you. The worst thing you can do is steal material. But it does happen. And then it comes down to good faith and how you deal with it after that. There's a thing called an apology. That works out there sometimes. Lynette, you put your camera on. Did you have a question?
I did. Thank you for noticing, and I apologize. I joined a little bit late because I've got two little ones you might hear in the background. I had a question about contracts. Felicia talked about having just taped a special. I also just taped a special. I know a friend of mine was interested in selling their album to Comedy Dynamics, but after hiring a lawyer to do the legal review of the contract, they realized it just wouldn't make sense financially, like what Comedy Dynamics was offering versus what the legal cost would have been was just it kind of nullified the whole agreement. And I just wanted to hear your take on that.
Believe me, I understand how that works because I know how little they're paying in advances, if they're paying in advance at all. The best you can do is the best you can do. It is always better to have a lawyer look at it. There are things called volunteer lawyers for the arts. They're based in New York City. They're lawyers and law students, many of them looking to get into entertainment law, but they're supervised by an actual entertainment lawyer. Cardozo Law School has a clinic mostly for motion picture, but they might deal with writers as well. And then there's the friend of a relative and relative of a friend route. Can you just take a look at this? Even if it's better to have somebody look at it, even if they're not an entertainment lawyer, than to have nobody look at it. Because some things will pop out at you, or at least at the lawyer, regardless. Understand that whether it's Comedy Dynamics or Amazon, they're looking to protect themselves. They're concerned with their bottom line, not yours. I do understand that, I agree with you, with the folks putting in. That is a very cute child. But if you can't, you
Thank you.
can't. And then at the end of the day, if something goes wrong, you go in front of the judge and go, Your Honor, I didn't know what I was signing. They gave it to me. They told me I had to sign it. I couldn't change anything. Help me. They're not supposed to, but sometimes they will. But you can't rely on that happening, certainly. But
Also, I would just add a maybe not more important than the money, but a very important thing to look at is the ownership of it. If they own it and if you own it, because you don't want to sign a contract and then want to do it again or put it somewhere and then you find out that they're suing you because they own the material now.
yeah, I mean, owning your product at the end of the day is the most important thing you have, because I mean, notwithstanding that little being I see right there, this material is your creation. So is the little being, but you've got to look out for it, and you've got to be able to make use of it, make the derivative work. If you get lucky enough to have a joke or routine that hits so hard that TV comes knocking, like you guys are probably too young to remember people like Gabe Kaplan or Freddie Prinze, but they took a routine and ran with it and made lifelong careers, TV, movies, etc. out of that. So that's what you got to do. Let's see. I know it's not again. I know it's not a satisfying answer. Maybe working communally can work well too, because if you know a bunch of people who are in that position, Comedy Dynamics has given the same agreement to everybody. So if all of you chip in to have a lawyer look at it for all of you, because it's going to be the same comments, that's another way of possibly doing it. Communal action. Comedians have never been good at communal action. There used to be a comedians union, short-lived in New York. I did some legal work with and for them. Mostly because I reach out and said, "Hey, I'll do it." But it's like trying to get comedians to work that way is like herding cats. The strike at the Comedy Store, notwithstanding, and that was what 40 years ago, something like that. Let's see. I'm running out of time. I've got something in the chat. As a result of artificial intelligence continuing to develop at a rapid pace, are there any new legal issues, precautions you foresee comics needing to plan ahead for? So many. So many. I'm working on I do an entire hour and a half session with my law classes on AI because it is the next thing coming. The issues aren't specific to comedians. You may have heard about a year ago or so, somebody claimed to have had an AI created George Carlin routine, which they recorded in something that vaguely sounded like George's voice. I communicated with his daughter Kelly when that happened, but she already had a law firm working on it. It turned out it wasn't written by AI. That was a false claim. Some DJs had actually written it themselves. There's going to be more of this. We will have new George Carlin routines. We will have new Lenny Bruce routines. AI will get better and better at these things. And then we will have virtually created comedians as well as virtually created musicians. I hope it doesn't go that far. I like live human being entertainment, but it's a problem. Brian, you wanted to say something?
Yeah, no, it's the George Carlin thing. That's great actually to hear that, because I remember hearing it going, and it was the first thing I ever heard on AI that actually sounded even moderately good. Supposedly, I haven't heard a single thing in comedy that from AI that was even remotely funny or amusing. It seems there's something about comedy that jams AR's radar. I'm not sure how long that's going to last, but music,
A sense of humor is a very human thing.
yeah, yeah. So that George Carlin thing, I heard that and I go,
For some
that's
people.
pretty. What's that?
For some people.
Sure.
Yeah.
Okay.
Yeah.
Some
But
people don't have it.
I heard the George Carlin thing, and I thought that's not bad. You know, it's not great, George Carlin, but it was not bad. And I was like, but that's impressive for a program to write something in the spirit of George Carlin. But hearing that it wasn't written, that makes a lot more sense, because I was like, that's too close to something. It's actually a pretty good rendition, you know. And so to hear that it was written by people, thank you for telling me that, because that's very
You're welcome.
heartwarming, actually.
All right. Lynette, I'll get you in 1 second. Let me deal with the one in the chat. Kathy writes, is there any protection from people we talk about in our set? I have a great closer in my set and vindictive sister-in-law. Okay, just what one wants. It's a whole nother discussion on the rules of libel. Your sister-in-law is probably not a public figure. I don't know who your sister-in-law is. I mean, she could be Elena Kagan for all I know, and then she would be a public figure. But in reality, you know, probably not. You've got to worry about defaming the person, because that's actionable. But talking about somebody in a non-defamatory basis is not actionable. And of course, the onus is on them to come after you. Which means they've got to spend the money on the lawyer and filing the lawsuit and all the rest of that. And I mean, your bigger problem, frankly, is Thanksgiving, not the court. Would be my guess, but I don't know that for a fact. Lynette, what you got for me? Oh, you put your picture back on.
I forgot it. I was so
I'm sorry.
fascinated by the libel, because I also talk about my husband's first wife in my set, and I had never really considered the the repercussions.
All right. I believe, Felicia, we're at time. Am I correct about that?
We have 1 minute. I guess if someone has one dying question, we can do that. But and there's Howard's information. If you have any further questions, you can reach out to him. And this was very informative. And I'm not going to be copyrighting any material.
You guys feel free to, you know, if you have questions we didn't get to, send me an email. You can get to my website through Court Jester Legal. That'll take you to the comedy page of my website. Howard Lieb Law is the general one, but you can get to the general from there. Again, I'm happy to hear from you if you've got questions that we didn't get to. I'll write you an answer to that. And Felicia, we can do this again sometime.
I have lots of questions for you.
Yeah, but well, I was about to say you have my phone number, but now they
Too
all have my phone
personal, too
number.
personal. Okay, thank you so
All
much.
right.
Thank you for everyone. And
Bye.
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 Oh, she's so cute.
Thank you. Bye.
Bye.